I want to talk to you specifically, not gun owners in general, not young shooters at the range, not first-time buyers figuring out their first purchase. You, the person watching this who has been a responsible gun owner for 30, 40, maybe 50 years. The person who has a bolt-action hunting rifle that belonged to your father. The person who has a revolver your grandfather carried. The person whose gun safe has been in the same corner of the same bedroom for 20 years, and whose firearms have been handled responsibly, stored correctly, and maintained carefully every single one of those years. I am talking to you because the gun law changes, taking effect this July, were written by people who were thinking about one type of gun owner, and you are a very different type of gun owner. And the difference matters legally, specifically, and in ways that are going to affect decisions you may be planning to make right now about the firearms you own and the people you want to leave them to. Here's what I mean. When most people heard about the new gun laws taking effect July 1st, 2026, the assault weapons provisions, the magazine restrictions, the new purchase requirements, they assumed one of two things. Either the new laws apply to them and they need to worry, or the new laws do not apply to them, and they can ignore this entirely. Both of those assumptions may be wrong, because here is what almost nobody is talking about in the coverage of these July 2026 gun law changes. The laws contain specific exemptions that were written deliberately with specific language for exactly the categories of firearms that seniors like you are most likely to own. Bolt-action rifles, lever-action rifles, revolvers, antique firearms, firearms manufactured decades ago, firearms inherited from parents and grandparents. Those exemptions protect you, but they do not protect everything. And the line between what is protected and what is not, specifically for seniors who are thinking about gifting firearms to grandchildren, about estate planning, about what happens to a lifetime's collection when the time comes. That line just moved on July 1st, and most seniors have no idea it moved. This video is going to tell you exactly where the line is. Let me explain why. July 1st, 2026 is specifically important for senior gun owners in a way that is different from how it is important for younger gun owners, and why the framing of this as a general gun law story has caused most seniors to either overwork when what they need is accurate information specific to their situation. Here is the demographic reality. Seniors who grew up in the 1940s, 1950s, and 1960s learned to shoot in a specific tradition. Hunting, competitive shooting, military service, firearms passed down through families. The guns in your safe are most likely not the semi-automatic rifles with detachable magazines and pistol grips that the new laws are primarily targeting. They are more likely bolt-action hunting rifles, lever-action rifles, revolvers, shotguns, and firearms that are decades old. Some of them antiques by legal definition. This is important because the new laws draw a specific and deliberate distinction between these categories. Virginia's HB 217, the most sweeping gun law change taking effect July 1st, 2026, explicitly exempts manually operated firearms, bolt action, lever action, pump action. These are not touched by the assault weapons provisions. They are not part of the magazine capacity restrictions that apply to detachable magazines. They are not affected by the feature-based definitions that determine what is and is not an assault firearm under the new law. For a senior whose collection consists primarily of these firearms, and that describes the majority of senior gun owners I work with, the July 1st changes may not directly restrict what you currently own or how you currently possess it. But here's the part that does affect you. The part that the general gun law coverage has completely missed. If you have been thinking about transferring any of your firearms to a child, to a grandchild, to a trusted person in your life, the rules governing those transfers changed on July 1st. If you have been thinking about what happens to your firearms when you are gone, the estate planning and inheritance rules that govern how your collection passes to your heirs, the framework for those decisions shifted. And if you have been considering any purchase at all, including helping a grandchild purchase their first firearm, new requirements in several states may apply. These are not the questions that the gun rights media is focusing on. They are focused on the AR-15 provisions, the magazine limits, the political debate. They are not sitting down and specifically asking, what does July 1st mean for a 70-year-old with a bolt-action rifle and a firearms collection he wants to leave to his son? That is exactly what I am going to answer right now. If you want senior-specific legal education on firearms law the moment it matters, hit subscribe right now. Now, let us go through exactly what changed and exactly how it affects you. Section 1. What the new laws do not touch. The senior exemption you need to know. Let me start here because this is the most important thing I can tell a senior gun owner about. July 1st, 2026. And it is the thing most seniors have not heard clearly. The major gun law changes taking effect July 1st. Specifically, Virginia's HB 217, the most significant of the new state laws, explicitly exempt manually operated firearms. This means bolt-action rifles, lever-action rifles, and pump-action firearms are not covered by the assault weapons provisions of the new law. Let me read you the specific language from Virginia's HB 217 directly, so you hear exactly what it says. The law exempts antique firearms, permanently inoperable guns, and manually operated firearms, such as bolt-action or lever-action rifles. Bolt-action, lever-action, and antique firearms. If your collection is primarily composed of these firearms, and for most senior gun owners who grew up hunting and who inherited firearms from prior generations, this is exactly the case. The assault weapons provisions of Virginia's new law do not restrict your possession of those firearms. Here's why this matters beyond the obvious. The exemption from manually operated firearms is not just a carve-out for a narrow technical category. It reflects a legislative recognition that the public policy concern driving the new law, semi-automatic firearms with military-style features capable of rapid fire, is specifically not what bolt-action, lever-action, and manually operated firearms represent. A bolt-action hunting rifle that has been in your family for 50 years is not the type of firearm these laws were designed to address, and the antique firearms exemption goes further. A firearm manufactured before 1899 is generally considered an antique firearm under federal law. Many seniors have firearms that meet this definition. Firearms inherited from grandparents, firearms purchased decades ago, firearms that are genuinely historical artifacts as much as they are functional weapons. These firearms carry additional exemptions under both federal and state law that are specifically worth understanding if they are part of your collection. Asterisk, asterisk your action step. Go to your gun safe this week. Look at each firearm you own. Identify whether it is manually operated, bolt action, lever action, pump action. Identify whether any of them may qualify as antique firearms. For the firearms in those categories, the July 1st assault weapons provisions do not create new restrictions on your possession. For any semi-automatic firearm in your collection, read on because the analysis is different. Section 2, the grandfather clause and what it actually protects for seniors who do own semi-automatic firearms or who own magazines that hold more than 15 rounds. The grandfather clause in Virginia's new law is the protection that matters most, and it needs to be understood precisely because its protection is real. But it is not unlimited. Here's what the grandfather clause covers. If you owned a firearm before July 1st, 2026 clears throat, that would meet the law's definition of an assault firearm, you can keep it. The law does not require you to surrender it, destroy it, or register it in most configurations. Your continued possession of a firearm you lawfully own before July 1st is protected. Same for magazines. If you currently own magazines that hold more than 15 rounds and you own them before the effective date, you can keep them. This is meaningful protection for seniors who have owned these firearms for years or decades. Your collection does not become illegal overnight because of July 1st. But here is where the protection ends. And this is the part that directly affects seniors who are thinking about estate planning, gifting, or inheritance. The grandfather clause protects your possession. It does not unconditionally protect transfers. Virginia's HB 217 allows limited transfers of firearms lawfully owned before July 1st, 2026. Specifically, sales to licensed dealers, inheritance transfers, repairs, and transfers to immediate family members. These limited transfer categories are preserved, but a general transfer, gifting a grandfathered firearm to a friend, selling it to a private buyer who is not an immediate family member, transferring it to someone outside the defined categories. Those transfers face new restrictions under the new law framework. For a senior who has been planning to give a specific firearm to a grandchild, that transfer may fall within the immediate family member exception, but the specific legal definition of immediate family in the law needs to be verified for your specific situation. A grandchild may or may not qualify depending on how the law defines the category and depending on subsequent guidance from the Virginia Attorney General's office. Asterisk, asterisk, your action step, asterisk, asterisk. If you own any semi-automatic firearm in Virginia, and you have been planning any kind of transfer to a family member through your estate as a gift, talk to a Virginia firearms attorney before making that transfer. The transfer categories that remain permissible are specific in getting it wrong. Transferring outside the permitted categories after July 1st creates legal exposure for both you and the recipient. Section 3. Estate Planning and Inheritance. The July 1st issue nobody is talking about. This is the section that matters most for seniors specifically, and it is the section that has received essentially zero coverage in the gun rights media focused on the July 1st changes. Here is the issue. Many seniors have not updated their estate plan to specifically address their firearm collection. They have a will. They may have a trust, but the will or trust was drafted years ago, possibly before the firearms they now own were purchased, and possibly without specific guidance about how firearms are treated differently from other personal property in an estate. July 1st, 2026 changes the legal framework in which your state will distribute your firearms, specifically your semi-automatic firearms in Virginia and Rhode Island. It does not change what you can currently own, but it changes what your executive or trustee can legally do with those firearms after you are gone. Here is the specific problem. An executor administering an estate has a fiduciary obligation to distribute assets in accordance with the law at the time of distribution. If a senior passes away after July 1st, 2026, and their estate includes semi-automatic firearms that are now subject to transfer restrictions, the executor cannot simply hand those firearms to whoever is named in the will without confirming that the transfer complies with the new law's permitted transfer categories. An executor who distributes a restricted firearm to a beneficiary who does not fall within the law's permitted transfer categories even while faithfully following the terms of the will may be facilitating an unlawful transfer. The solution is not complicated, but it requires action before it becomes a problem. Update your estate plan to specifically address your firearms. Work with an elder law or estate planning attorney who is familiar with your state's current gun laws as of July 1st, 2026, not as of whenever your existing will was drafted. Consider establishing a firearms trust if your collection is substantial. A firearms trust provides a clear legal framework for the ownership, use, and transfer of firearms that is specifically designed to comply with applicable gun laws at every stage. And have the conversation with your intended heirs now, while you are here to have it, while the decisions can be made with your input, while the legal planning can be done proactively rather than reactively under the pressure of a state administration. ***, your action step. Pull out your existing estate planning documents. Read the section if there is one that addresses your personal property and specifically your firearms. If there is no specific firearms provision, or if the will was drafted before the July 1st changes, make an appointment with an estate planning attorney this month. Not because your firearms are in immediate danger, because the legal framework for transferring them just changed, and your estate plan needs to reflect the current framework, not the prior one. Section 4, Helping Grandchildren Purchase Their First Firearm. New requirements. This section addresses a specific situation that is extremely common among senior gun owners, and that is now subject to new requirements in several states. Many seniors are the person in their family who introduces the next generation to responsible gun ownership. They accompany grandchildren to purchase their first firearm. They provide guidance on selection. They sometimes provide financial assistance with the purchase. This is a tradition of responsible gun ownership mentorship that has been part of American family culture for generations. Several states have now added requirements to this process that seniors helping grandchildren navigate a first firearm purchase need to know about. In Colorado, beginning August 1st, 2026, individuals who want to purchase most specified semi-automatic firearms, including certain rifles and handguns with detachable magazines, must first obtain a firearm safety course eligibility card. To receive the card, the applicant must complete a background check and a state-approved firearm safety course. This means a grandchild in Colorado who wants to purchase a semi-automatic rifle or a handgun with a detachable magazine after August 1st needs to complete this process before they can buy. A senior accompanying that grandchild to a gun store in August needs to know that the purchase cannot happen without the eligibility card, and that obtaining the card requires advanced planning, including completing the safety course before the purchase visit. In Virginia, the minimum age for purchasing certain firearms has been raised to 21. A grandchild who is 18, 19, or 20 years old, who would have been legally able to purchase certain firearms in Virginia before July 1st, is no longer able to purchase those specific categories after July 1st. ***, your action step. If you are planning to accompany a grandchild or other young family member to purchase a firearm in the near future, and you live in or plan to purchase in Colorado, Virginia, Maryland, or any other state with significant 2026 legislative activity, verify the current purchase requirements in that specific state before the purchase visit. The requirements that applied the last time you helped a family member through this process may have changed. Section 5. The 4 things every senior gun owner should do before July 31st. Let me close with a concrete, actionable checklist, because what I want you to walk away from this video with is not anxiety about what changed, but a clear sense of what to do about it. Action 1. Inventory your collection by firearm type. This week, before anything else, go through every firearm you own and categorize each one. Manually operated, bolt action, lever action, pump action, semi-automatic with a detachable magazine, revolver, shotgun, antique. This inventory tells you immediately which firearms are in the clearly protected category under the new laws, which are in the grandfather clause category if you are in Virginia or Rhode Island, and which require further analysis. Action 2. Review any planned transfers before proceeding. If you have been planning to give any firearm to a family member as a gift, as part of estate planning, as part of helping a grandchild with a first firearm, pause that plan until you have confirmed that the transfer is in a permitted category under the current law in your state. This is not a permanent pause. It is a due diligence pause. Most of the transfers seniors are contemplating are in exactly the categories that the new laws specifically preserve: immediate family transfers, inheritance, gifts to adult children. But confirm before you proceed, not after. Action 3. Update your estate plan to address your firearm specifically. If your existing estate planning documents, your will, your trust, do not specifically address your firearms collection with current law in mind, make an appointment to update them. This is a one-time conversation with your estate planning attorney that, once completed, provides a clear legal framework for your entire collection for as long as you own it. Action for talk to your family now. Tell your children and grandchildren what firearms you have, where they are, and what your intentions are for them. The combination of proper legal documentation and family communication is what prevents estate disputes, unintentional legal violations, and the heartbreaking situations I have seen where a lifetime's carefully maintained collection creates legal complications for a family that was not prepared for the current legal framework. Let me bring everything together. If your collection is primarily bolt-action rifles, lever-action rifles, revolvers, and antique firearms, the July 1st assault weapons provisions do not restrict your possession of those firearms. The exemptions written into the new laws cover exactly the types of firearms most common in senior collections. If you own semi-automatic firearms that were lawfully purchased before July 1st, 2026, the grandfather clause protects your continued possession, but it does not unconditionally protect transfers. Know the permitted transfer categories before you gift, sell, or distribute any of those firearms. If you have been thinking about estate planning for your collection, July 1st changed the legal framework your executive will operate under. Update your estate plan now while you are here to guide it rather than leaving that complexity for your family to navigate later. If you have been planning to help a grandchild purchase their first firearm, know the current purchase requirements in your state before the purchase visit. Several states have added steps that require advanced preparation, and the 4 actions inventory your collection by type, review plan transfers, update your estate plan, and talk to your family. I open this video by talking directly to you, the person who has been a responsible gun owner for 30, 40, 50 years. The person whose firearms are not statistics in a policy debate, but a lifetime of responsible ownership, a connection to tradition, and in many cases, a link to the people who came before you. The laws I described today do not erase that. They do not take your collection. They do not eliminate your rights, but they change the framework, specifically in the areas of transfer and estate planning, in ways that require your attention. Before those changes create complications you did not anticipate, you have that attention now. Use it. Share this with every senior gun owner you know, particularly every senior who has been following the July 1st coverage and is not sure whether it applies to them. Because the answer for most seniors with the types of firearms most seniors own is more nuanced and more reassuring than the headlines suggest. But nuanced and reassuring still requires knowing the specific answer, not just assuming it. What happens when you want to formally transfer a bolt-action or lever-action rifle to a grandchild, and you want to make sure the paperwork is done correctly, including through an FFL, if required with proper documentation for your estate? Check out the next video, where I walk through the complete legal process for intergenerational firearm transfers, from documentation to FFL involvement to estate planning integration. I will see you over